Hello everyone, and welcome to the very first recording of the Down Under Visa Q&A group. Okay, I'm just going to work my way through what questions that we have here. Okay, here we go. Christopher asks, my fiance's illegitimate daughter has the surname of her father, who she has not seen for 4 years. Can we expect any problems in the visa process? Okay, look, this is an issue which will apply to both partner visas and with tourist visas. Australia complies with international law, and it requires that somebody who has custodial rights over a child has a say in whether they leave the country or not. Put yourself in the same position. You wouldn't like it if your child was taken by your ex and whisked off to the wilds of the Ukraine or somewhere, and you couldn't access them. That would be awful. The way the system works is that they go by whatever the law of the particular country is regarding custody. Philippines, it is fairly easy when the child is this hideous word, illegitimate. Illegitimate is an archaic legal term which is used here. I don't like it. It sounds like they're saying the child is of no value. They don't mean it like that here, but unfortunately, that's what the word means. Okay, illegitimate daughter has the surname of her father, who she has not seen for 4 years. Okay, illegitimate, what it means is the child was born out of wedlock. In the Philippines, if a child was born out of wedlock, unless the child was later legitimised by the couple marrying, the child remains illegitimate, and the father has no rights whatsoever. In this case, he clearly chuffed off 4 years ago. Obviously not a great dad, but he could have been a fantastic dad, but because they're not married, he has no rights. But even the fact that she has the surname, the laws used to be that the child had to have the surname of the mother. The laws changed. The mother can give the surname of the father if he acknowledges his paternity, but it still doesn't change anything. He still has no rights. So in this case, no permission is needed. However, if the parents were married, well, they actually would need his written permission, and if he says no, well, then it's no. In this case, you have nothing to worry about. So that's good. Okay, from Josh. Question, we have a friend here in Australia, had her sister here last year on a tourist visa, no problem. Now they applied again for the same visa for her sister, but was denied. Anything they can do? Can they reapply ASAP, mate? Well, yeah, they can reapply, but whether it's going to be successful or not is hard to say. They will, of course, look at the previous application. In most cases, it just means they weren't convinced that she's a genuine applicant. Family member applications are often just that little bit iffy because of the fact that salaries are very low here. Somebody could, what they earn in a month, they could earn in a day, picking zucchinis or picking oranges somewhere. So, and a lot of families will get their sister in and let her go fruit picking and what have you to earn some money. So they do have a legitimate concern there. So that's the point. Can try again, but really, especially if she's a working age, it's still always going to be that little bit iffy. Why was it granted before and not now? Well, the case officer before was obviously convinced. Second time, obviously, was not convinced. It's a bit, like tossing a coin sometimes. But anyway, they can try again. We can have a look at it, but no promises. So, Graham here. Okay, I do have a question. Magdalena's fiance visa expires on the 4th of January. We're in the process, you and us, of getting our next visa, which will be a subclass 820, which is what's required with a fiance visa after the couple marry. Okay, we are in the process of getting it. What happens if we don't get it before the 4th of January? Look, as long as the application is lodged before then, it isn't a problem. Subclass 820s for for fiance visa holders are usually fairly quick. We've had them granted the same day. Most cases they're granted within a month. But look, if it isn't granted by the 4th of January, she will automatically go onto a bridging visa A. So don't need to apply for it. It will happen automatically. What will happen is the midnight bang, one visa finishes and the bridging visa A cuts in. So nothing to be concerned about. That keeps her lawful in Australia, so she's not at risk of being unlawful or anything like that. Okay, well that's all the questions we have this week, and looking forward to more questions next week. Just ask away and the answers will come up in a video here on the Q&A page. Thank you. Thank you. I hope you enjoyed this video. If you enjoyed it and you would like to subscribe, you can click on the little button down the bottom corner there, and you can subscribe to our YouTube channel. There are regular articles on aspects of Australian visas to the Philippines on www.downundervisa.com.au. There's a blog page you can subscribe to. There is a free visa assessment form, and there are regular articles on aspects of Australian Filipino relationships, which you can see on www.filipinawives.com.au. If you can please share these articles and these videos on any of the social media that you use, we would appreciate that. Thank you.